if I don't do nothing else, I'm gonna talk that law. Let's talk about it. But before we begin, for those who may not know me, I'm a Texas trial attorney. Y'all see the law license on the wall, signed by the 9 justices of the Supreme Court. I was minding my business. I was drinking my water. And somebody said we're gonna talk wide sales today. So, okay. So without further ado, let me bring them up. Hello. Can y'all hear me?
We can hear you great. Can you hear us?
Yes. Hello. Now, isn't this a treat and a surprise?
Well, it's a treat for us to be here with you.
I was expecting 1, and now we got 2. Wow. Thank y'all so much for taking the time out of your busy schedules. I know that y'all have been tied up with this case for the past several years, and I know y'all have a lot of work to catch up on, so we're not going to hold y'all too long. But I do thank y'all so much for stopping in. If y'all don't mind just introducing yourselves, I'm pretty sure y'all need no introduction.
I'm Bruce Harvey, and this is Nicole Westmoreland. We worked together, and we worked together on the YSL case for the last couple of years.
Okay. And is Georgia your primary practice state, and Fulton County your primary practice area?
Well, I think depends on how you define primary. Both of us go all over the place. We have cases all over the country and all over the state. So, but we're based in Fulton County, and we do a lot of work in Fulton County.
Oh, wow. Okay. So it's safe to say y'all are accepting new clients.
Yes, as long as the check clears.
So if y'all watching this later on, as long as the check clears, you might have some good counsel. So do y'all mind just telling me, how did y'all get involved in the longest case in the history of the state of Georgia?
Well, we got in late. Our client's wife came to me early on in the case, but wasn't prepared to retain us. After the case developed and started going forward a little bit, they decided that they wanted to go ahead and retain us and had the ability to do it. So we got on board, not understanding and not ever believing that it was going to be 2 years down the road before we came up for air.
Wow. So y'all had no idea going in that it would ever be this long.
Well, I don't think anybody ever had an idea that it would be this long. You know, you get a case like this with that many defendants, and ordinarily it's split up into manageable groups, both in terms of defendants and the primary activities that each of those groups of defendants are charged with. You know that. You're a trial lawyer. You've gone through that process 100 times. So
nothing on this scale.
Well, I know nobody has. No. That's the thing. So when we first got in, we anticipated. They came to me. I wanted some help from Nicole. She's a very forceful, vigorous defense attorney, and so we agreed to get on the case, believing that anybody under any set of circumstances would sever the case out into manageable groups. We were wrong, and I'm blaming that on Nicole. But we were wrong about that. So, you know, we've been day to day since on or about December 13th of 2022. We have been continuously going to court in this matter.
Wow. And how long have you both known each other?
Well, it seems like 100 years.
Years.
Yeah,
because
several years.
We know you started off kind of in the forefront, and then we seen Attorney Westmoreland appear, and she was cross-examining a witness one day, and everybody was like, who is this woman? Where did she come from? But I guess she's been there all along, but the way the courtroom is designed, we rarely get a glimpse of the back of the court. But y'all always had a familiarity with each other. Y'all always known each other.
We had tried a couple of cases together prior to getting involved in this case. And there is a great balance that I think that we have. And there are, of course, as you know, there are witnesses that Nicole would be better suited to cross-examining, and there are witnesses that I would be better suited to cross-examining. So we work, I think, very effectively in a good balance. So that's how we decided to work this case. But in this particular case, it is unusually long. But you know something? 22 months down the road, we still haven't given our opening statement.
Wow.
We reserved giving opening statement. We were the only defendant to reserve giving opening statement. So for 22 months, we haven't even opened. We resolved the case before we actually opened.
Wow. And I always wondered about that strategy. Have you ever reserved your opening in the past, or is this something that you decided to do for this particular case?
No, I think it's situational. It's fact dependent. So I have done it before. In fact, we did it, David Wolf and I, a great lawyer, David Wolf and I did it in the Ray Lewis trial.
Oh, wow.
So that's how long, that's how old I am. Nicole's the baby of the group.
I mean, did y'all ever think, I don't even think, how can you even imagine that we would be here where we are today after this roller coaster of a trial?
Well, it's still going. Both Nicole and I popped in this morning to see what was going on. It is definitely moving faster for those of you who are watching it live on YouTube. Now, I know that Jeffrey is not there and he is the big draw. But, these two young men that are on trial are still on trial for their lives. That case is still going on. So we want to be able to support those young men who have enough courage to continue forward. And that's what they're doing. And their lawyers are doing a great job.
And if you don't mind me asking, Attorney Westmoreland, when you objected, I don't know, was it last week? The time is moving so fast. Did you think that objection would be the straw that broke the camel's back, the objection to turn this case upside down?
So, I made a motion, for a mistrial, and I did not know when I made the motion that would be the straw that broke the camel's back. But once that was indicated, I wasn't that surprised because, as we had motioned for mistrial on several occasions before that, and we think it was warranted.
And I believe the witness, not to get too far into the details of the case, but the witness had made a statement prior to your objection. So that was actually, I believe, his second time making a statement about the incarceration of either your client or some client by the name of Quay. And it got to a point where enough was enough. And go ahead.
No, I'm agreeing with you. Go ahead.
Yeah,
you're right.
There's no question about that. But we had already had the fact, the judge had already ruled with us to take that out because there was some confusion about who it may relate to. So the judge just made him take it out, period. But they didn't do it when they handed the witness the document. And what was different that was being displayed to the jury, and it was different than what was being displayed to the YouTube audience. And then who was it? Slime Life Shorty.
Yeah.
He just looked at it and read it. We can't blame him. It is squarely the state's fault. And something, they've been doing it over and over and over and over and over. And we looked at each other, and we had been making motions for mistrial for 22 months. So there was no reason not to make it. It worked out.
Yeah,
it was the right time, right place, and Nicole did a great job in making the motion and arguing it.
Yes, I definitely agree. And would you believe it or not, today I was watching briefly a few moments of the trial, and the witness was asked to read something from an exhibit, and he said it's not there. She said, turn around. He said, okay, well, it's on the screen behind me, but it's not on the one in front of me. So I was like, okay, so we still haven't learned that to only show what you need to
Exactly. I mean, history repeats itself over and over and over again in this case. And, you know, at some point, like you said, like you all have used the term, the straw that broke the camel's back. And this is it. This is a great example of that. And, you know, as a lawyer, you know that there just comes a point where either you or the judge or your opponent comes to a point where you just can't keep going forward in that same style, and something is going to have to be done about it. And, you know, in a case of this significance, in a case of this importance, in a case where people's lives are on the line, you just got to be more careful and do it right.
Yes, I agree. And I believe the court actually came to a boiling point, was like, okay, what's going on? I'm trying to fix the sloppiness. I'm trying to help out, but it's only so much the judge can do before her hands are completely tied. And I believe she came out and she said she was going to deny a mistrial with prejudice, but she was going to entertain one without. And that caught me off guard, because I was like, okay, she's being serious now. But then when the cameras cut, I was like, okay, this may be the real deal. What was going through y'all heads at that moment?
Well, I mean, what was the answer to the question? What should it be? Did we want the mistrial without prejudice, which, you know, that means that the state could bring the charges back. And so that is a big decision. It was going to be one of the most important decisions that we were going to make in this trial. So that's what we were thinking about. What should we do?
Well, you know, it kind of put us on the spot.
It did.
And if any of y'all have been following it, we have made motions for mistrial. I made motions for mistrial like 50 times Seriously. During the case. And they were not mistrials with prejudice. They were just motions for mistrial or severance or prejudicial misjoinder or a spillover. Whatever it was, we made motions for months and months and months. Now, and the judge routinely denied them, the predecessor judge, Judge Glanville. But, you know, so it would not be keeping up with what we had been doing and the precedent that we had been setting if we didn't ask for the mistrial. But then the judge said, well, do you really want one? And that's kind of stopped everything. That kind of stopped everything short. And everybody in the trial was put in the same basket. And the judge said, well, we're going, you know, y'all talk about it, because if you want a mistrial, now's the time. So that's what precipitated everything.
Wow. And based on that motion, lives literally have been changed. I mean, people are at home now, and your client is obviously in a better position than the start of the trial. I believe most of the people that took pleas so far. So I do believe that was really a good strategy. Even the plea itself was exceptional. The way that he didn't have to have any factual acknowledgments, murder charges dropped, gang charges dropped,
gun charges dropped,
how did y'all do it?
Nothing. I mean, all he said was, okay, RICO conspiracy, the underlying predicates are offenses that he had already pled to. I mean, and you know, thankfully, Jeffrey is at home. He's going to be able to start recording again. Pretty much everybody else's case was resolved. So it really was a tipping point in the trial. I mean, I think it made the difference. And thankfully,
I believe the other side, and this is just my personal opinion, was shook when they heard you explain that the plea can still go forward without him admitting essentially or pleading guilty to those other charges. The conspiracy still was pled to, and the judge still had the authority to accept it. And I think that, to me, it appeared you caught them kind of off guard that he was able to just plead guilty to that certain aspect, and the case is resolved.
And I think it was, I truly think this is a great young man. We love him very much. He has communicated with us since then. And we've spent the last 2 years getting to know him, being his friend, seeing him, talking to him every day, going through this with him and the ups and downs and COVID and sickness and everything. It's almost like a marriage, in sickness and in health.
Yeah.
We're there for you. So we think it's a great resolution. We're glad Jeffrey is back, and the Thugger is going to produce some music now for everybody. And he's going to get with Gunner. It's going to be Gunner and Thugger again. It's
right.
great.
And I'm glad that was actually brought up to the court to allow that to happen, because people were speculating. But that was good that his attorney was able to ask the court for that exception for a certain group of people to allow him to continue to produce his music, which I'm sure a majority of his fan base been waiting on that for the longest.
They have.
And a lot of people don't understand about the making motions for a mistrial. Why would you ask for a mistrial if you already know the judge is going to deny it? But a lot of times we have to make that motion to preserve it for the appellate courts. I'm sure it's similar in Georgia. Is that the case?
It is. It is.
And you don't know that the judge is going to deny it.
You don't know.
Well, we knew Glanville was going to deny it. That's for damn sure.
And a lot of times as attorneys, we have to really gamble. We have to ask for the mistrial, obviously, for the record purpose. You want to preserve it. But at the same time, we're like, okay, well, what if the judge really grants it? Do we really want to start this thing all the way over, give the state another bite at the apple? They're going to know our game plan. Do we really want to do that? So a lot of times, not all the time, but a lot of times, a second time around usually favors the state. Is that a fair statement?
Absolutely.
Oh,
You're quite right about that. But usually, you know something, you make a motion for mistrial in a 2-week case, and you're in the middle of a 2-week case and a 3-week case, and there's not that much behind you. So the strategy is a little bit different. Here was a motion for mistrial after 9 months of trial evidence, 2 years in the case, but a lot of that was jury selection. So the strategy is a little bit different when you got 9 months of evidence behind you, as opposed to a couple of weeks behind you. So that was a big factor as well. Also, there's a whole nother group. There's a whole additional group of folks waiting to resolve their cases and maybe coming up to trial time as well. So all of that played in. You know the strategy. You hit the nail right on the head.
Okay, perfect. This is just such an awesome time to have you both here, because I was trying to stay away from certain topics, but I know you've been practicing for so long. So I know somebody said in the chat, you're blunt. You're going to stay
I've been practicing longer than you've been alive.
Right. And I try to tell the chat, because a lot of times they don't understand. We don't really want to destroy our relationships with certain prosecutors or certain judges, because we might appear before them again. This is not our only case. We're going to have more cases, and you're probably going to need to work with that prosecutor, work with that judge. But at the same time, we still can call the truth the truth. I mean, we all witness the state's performance. We witness certain judges' actions, and I think that someone had to say something. And I like the energy that y'all brought. I mean, he was spot on as far as speaking up for the rights of Mr. Nichols, who is, your client.
Really appreciate that, and thank you very much. And I know, and we know, that you do the same thing for yours.
Oh, yes, absolutely. I was like, they are my spirit animal. If I was in the courtroom, people always ask me, who would you mostly relate yourself to? And I was like, okay, that team for sure, because they are going to call it out. And sometimes people will get upset. It's okay, get upset, and then tomorrow, good morning. We start all over again. So it's not a big deal. Prosecutors and defense attorneys are adversarial by nature. If you want one thing for lunch, they're going to want another thing. It's just the way it is. We don't always agree, and that's okay. But as far as your handling of this case, both of y'all were excellent and brilliant. I do have a few more questions that I will let y'all go. As far as the bail system in Georgia, I know that it's very oppressive. A lot of states are where they can, and when I say they, the state can hold a defendant in custody, even though they haven't been convicted of a crime for years. And a lot of times defendants may plead guilty just to go home. They might not even be guilty of the actual crime, but they want to go home, or they don't want to face the exposure of the opposite end of not pleading guilty. So do you think that Georgia, as well as other states, should take a look at bail reform when it comes to clients being held in jail before they are found guilty of a crime? I know the question was long.
I mean, of course.
Yeah, absolutely.
Well, but what if somebody came to you and said, hey, we know you're innocent. We know the law presumes you're innocent, but we're going to punish you by keeping you in jail for 2 years before any resolution of your case, or 3 years, or however long it might be. You'd say, well, that's the craziest thing I've ever heard of, because we are incarcerating you. We are keeping you in prison, even though we're saying that it's just pretrial detention. So the answer to that is of course. And by the way, we are going to visit with our spirit animal, Gray Goose, here in a little while.
Come on.
But you're absolutely
Shout out to the Gray Goose.
But you're absolutely right. I mean, look at this case. Look how many individuals that the state stood up at bond arguments and argued that this person should be held without bond, and they're such a danger to the community, and then turn around, months/years later and present the opportunity to get out today. Here you go. I know it's Christmas. I know that you have a family member sick. I know that you have kids, game that you need to attend. And all you have to do is initial by these factual acknowledgments that you didn't write, that the state wrote for you, and you can go home today. Does that sound right?
And I believe that actually happened when one of the defendants, he actually appeared here a while back, and he was taken back into custody because some of the factual acknowledgments either weren't true or were slipped in. It was a lot of confusion.
Yeah, he got 5 years. He got 5 years in prison because he didn't, according to the state and according, unfortunately, to the judge, he didn't abide by the factual acknowledgments that he swore to when he pled. So,
wow.
Of course, I know you exist, Thugger Daily, and you're killing me there, man.
Of course we do, and thank you for covering this.
Shout out to Thugger Daily. Thugger Daily has really been on top of this. There's been a lot of other content creators, but Thugger Daily, they get documents posted. They really did a good job of exposing.
No, they did a great job,
and we appreciate it. We need it. Yes. Public trials are so important, so we need it, and we appreciate it. Thank you.
Yes, when we want something to know something, go to Thugger Daily, take refresh. Do they have the documents? What was said? What was not said? But I'm sure Mr. Nichols is happy with the resolution. I'm sure y'all are excited about the resolution of this case. I don't think that based on the circumstances, it could have gotten any better. A lot of people say, well, just ride it out. It's only 2 more months, 3 more months, 4 more months. But we are sitting at home. They are sitting in that jail cell in those conditions every single day. And they have family, they have loved ones. And it comes a point in time where one may say enough is enough. Yes, I could have got a not guilty verdict, but the opposite end of that, I get to go home now. I get to come out and live a happy and successful life. So I really think that this was the best outcome for Mr. Nichols. And I'm sure y'all may agree.
Well, we certainly do, and we appreciate you saying that to us. We appreciate you asking us on, and I hope everybody that's watching this appreciates you as well.
Oh, thank you so much. Well, I definitely appreciate y'all stopping by. It's been an honor. I know that it was going to be one, then we got two, and this is just perfect. So I'm sure the chat, everybody's saying that they thank y'all so much. So I definitely appreciate it. And if I'm ever in the area, I'm going to stop by, look y'all up, and invite you for lunch.
We'll visit with my spirit animal.
Oh yeah, we're definitely going to do that for sure. I'm going to let you know when I'm heading that way.
All right. We're taking off.
All right.
Okay, thank y'all so much.
Thank you for having us.
Yes, thank you so much.
All right.
Yes, y'all. That was really nice of them to both come on, and that was really good. Yes, and thank y'all all. Y'all were being so kind. Blue Skies, Here Comes Drama, Lady J, Monica, Curly Like Diva, Amy, Queen T. Thank y'all so much for coming on and supporting the stream. And y'all members, thank y'all for being members of the stream. Yeah, if y'all don't mind liking the video so more people can see it, more people can get the side of the story that we normally don't get to see. We don't always get to hear from the attorneys once the case is over with. And when you like the video, it circles through the algorithm so more people can see it. And you can get the word out about the things that's going on in Fulton County. So thank y'all so much for coming by and supporting. I know I haven't been on in a while. Like I said, I'm not retired. I still work, but I definitely appreciate y'all stopping by. And for the new people, if y'all want to come back with more content, feel free to hit the subscribe button, and I definitely bring more back. Thank y'all so much. Everybody said that was amazing. Thank y'all. Somebody said he hiding in the bushes, setting up interview. Great interview. I shared to my 20 followers on X. Hey, we got to start somewhere. Thank you for doing that. Thank you. Thank you, Cat Williams, for stopping in. Thugger Daily, thank y'all. Tall Glass. Thugger Daily, great interview with some great people. He said, of course you know he know you exist. Who don't know, right? I mean, you have to be living under a rock to not know that Thugger Daily exists. And a lot of the content creators. Thank you so much, India. Yeah, thank y'all. Thank you, Keys Mobile. Keys popped in early. Cat say we close to 4K. What we looking like? She say we close to 4K, y'all. Where we at? And just like that, y'all brought me over. Thank y'all. That's really kind of y'all to push this over that hump to over 4,000 subscribers. Thank y'all. I see y'all coming in now. Thank y'all. Y'all are really nice. All right. I was trying to read some of y'all comments. Thank all of y'all. People that got here early. 313, the best side. I see you. Thank you. Chicky Brewer. Yeah, thank all y'all. Thank y'all. I'm just reading y'all comments. Thank y'all. I see y'all. All right, y'all, let's go. He said, "Chuck, you know there'll be something good. I want this stuff in my face." All right, y'all, I gotta go. Let's see, working hard. Thank you for the interview. Yes, thank all of y'all. Thank you, Cat Williams. Definitely appreciate you. It's a great interview. Proud of you. You are working to tell you. I definitely gotta do that. Take care of my client. Oh my God, I missed it. Just go back and watch this. Cool. We're glad to see y'all again. All right, y'all. Let me get out of here. Thank y'all so much for people that like the video, the people that subscribe, my members, and the people that was kind to donate to the stream. Thank y'all. Thank y'all. Thank y'all. All right, let me go. Let me give my legal disclaimer. No legal advice intended. I'm a lawyer, but I'm not your lawyer. I'm just here to talk their law. All right, thank all of y'all. Y'all have a good night, and hopefully we'll see y'all soon.